Hi guys, this is attorney Joseph Ott back at you with some more videos. In my daily practice, I've been trying to put more of these videos on the internet, but I wanted to put some more sort of academic ones that explain the relative analysis that you're going to go through when you're assessing a personal injury case. So to begin with, when we are looking at a personal injury case, we're only going to take a case that we can get paid on. And that premise is very important because it means that the majority of our cases are going to sound in negligence because insurance has a prohibition on paying for intentional acts. So insurance companies generally will not pay out if you've done something to intentionally hurt someone else. And that's because it's trying to prevent, arguably, this issue where somebody would be attacking someone else and then splitting the insurance money with them. So that's an uninsurable risk, and we'll talk about that in another video. So what you're looking at with a negligence case, you're always going to be trying to assess if the actions that the defendant took in the case were sufficient to be legally ascribed as responsible for the harm that we're looking at. Now, when you are in law school, case law is generally going to analyze questions of negligence and causation by looking at a four-element inquiry. They're going to look at the duty, whether the person owed a duty to the other person. They're going to look at whether the duty was breached. They're going to look at whether the breach of the injury was a foreseeable consequence, the proximate cause inquiry, and then they're going to look for damages. But for me, the on-the-ground relevance of that four-part inquiry is pretty limited. Really what you're looking at are damages. Damages are the only question that's truly relevant to me when I'm looking at whether or not I'm going to take a case. Because if somebody has a lot of damages, then it's much more likely that a jury, for psychological reasons, is going to find that there was fault and that there was causation. Now, if you're looking at damages, you're always going to want to present your damages argument in a way that frames the damages that occurred and couches them in language of causation. And the causal understanding that you want to have for these events is therefore very, very high. As lawyers, we cannot rely only on this kind of arithmetic approach to causation. And we need to be able to understand the causal process in its entire complexity and indeed profundity. So when you're looking at causation and the way that I've divided it up, you're looking at two different sets of questions. In the first set of questions, you're looking at whether the injury was actually caused by what the defendant did. And in the second, you're looking at whether the defendant can be held legally responsible for causing that injury. The first inquiry is the actual cause one, and that's a much broader, almost metaphysical inquiry, because when you're examining the cause of any particular event, it's possible to look back in the past and find numerous prerequisites for that event to have occurred and therefore to have actually caused that event. So for instance, the example that I use is when you drop your cell phone and the screen breaks. So what caused that? Well, we can look at a lot of different things, right? We can look at whether the fact that gravity exists caused the phone to break. We can look at whether the tensile strength of the phone and the screen on the phone was so small that it was caused to be broken by a relatively smaller force, because, for instance, if the glass had been engineered more to a higher specification, then the injury wouldn't have occurred and the screen wouldn't have broken. We can also look at what caused the person to drop the phone. So were they simply not paying attention? Did something distract them? And can that thing that allegedly distracted them be isolated as being the cause? You know, if you think about it, this notion of causation is truly a profound one. And most of the major religions are going to be addressing the question in one way or another. For the Christians, causation is caused by, in the initial instance, by God, the initial mover. And that is the only cause that has no other causes. And if you look at the Buddhist tradition, causation is intractably bound up with the notion that there are no events that occur in isolation, and that all events can only properly be understood by locating them within the particular context of causation that gives them their meaning. So this question of causes is a complex one, to say the least. And so we narrow that scope in two ways. So the first way that we do it is the on-the-ground legal approach, which is that if the event could not have been said to have occurred but for the factor that we're trying to ascribe responsibility to, then that event did in fact actually cause it. So, but for me dropping the phone, the screen would not have broken. So that shows that, me dropping the phone was a but-for cause that was a prerequisite to the phone breaking. The other element that we're going to be examining is proximate causation. So proximate causation is the more legalistically precise mechanism, and proximate causation is always going to entail cultural and contextual norms regarding responsibility for a given activity. So the law does not want to have people be responsible for causing damages that they could not have foreseen. And that's because we want to only hold people responsible for conduct that they could have prevented. Otherwise, the law is merely a punitive tool and is not one that is entirely indicative of the general overarching aims of the law, which are to provide retribution for harms that have occurred and that sort of thing. So the proximate cause inquiry is going to look at whether the general mechanism that caused the harm that we're examining was a foreseeable risk of what made the person's conduct negligent. So this notion of proximate causation really collapses all four factors. And we first assess, was there an actual cause there? And that inquiry is useful because it allows us to identify any of the numerous causes that we can pin the case on. And then we bring it back with the proximate cause issue and we say, okay, looking at this actual cause, did this actual cause entail a notion of responsibility? Meaning, did this actual cause result from something that was foreseeable at the time that it occurred and therefore could have been prevented? So, that's my basic understanding of causality. It's obviously a very complex topic, and I put some materials on the page that I hope will help you to understand it yourself and also to come up with some good causation arguments, which is really the import of it to begin with. Thank you. That was my understanding of causation.